You'll see the title of the session, We Wanted Workers, but Human Beings Came. And this comes from the words of the Swiss philosopher Max Frisch. We used it in a report that OHCHR published a couple of years ago now. And if you haven't seen it, I think we have some physical copies in the room, but of course it's also available online. And we named it this way because in the Asia-Pacific region, the discussions on labor migration, and particularly low-wage temporary migration, also well-meaning discussions of this migration can often imply that the central subject, the people that move, are not people, but units of labor, senders of remittances, growers of GDP, essentially commodities. And we wanted to recenter the human person in these discussions. Because the experience of many of the people, and we'll hear that from our panelists, the experience of many of the people that move is often one of precarity and vulnerability. So we wanted to reframe the discussion towards an understanding that migrants on these programs are not only, they are workers, but they are not only workers. They are parents, they're spouses and partners, they're children to elderly parents. They are people who exist within racialized minorities, within gendered discourses and hierarchies, and within intersectional spaces. So we wanted to go beyond an examination only of the decent work deficits, even though we recognize and appreciate that these themselves are challenging. But we wanted to investigate, for instance, what justice, what remedy looks like, or should look like for migrants and their family members on these pathways, to bring a holistic and comprehensive human rights lens to temporary labor migration. So in the research that I mentioned, we found that many of these programs impose a series of restrictions on the human rights of migrant workers, including, for instance, denial of civil and political rights, such as the right to marry, to family life, restrictions on freedom of association and expression, as well as limits on economic, social, and cultural rights, such as access to healthcare, adequate food, housing, and sanitation. We found, for instance, that male migrant workers, men, struggle to access mental health care, often on the basis of gendered stereotypes, or that men were constructed as threats to society and relegated to segregated housing far away from public spaces. Women migrant workers on these pathways are confined to gendered work sectors, protected from migration through paternalistic restrictions on their movement. And low-wage migrant workers are often subject to class-based discriminations on the basis of their socioeconomic status. The costs of temporary labor migration go beyond the question of a financial cost-benefit analysis. Their lack of attention to the family, for instance, as a natural and fundamental unit of society, represents a sociocultural cost to society in their mandated and often long-term family separation. There is a personal and societal cost to women and men who are prohibited from marrying or establishing families while they work on these pathways. There is a cost to children who are deprived of one or both of their parents for much of their childhood. In our research, we found it important also to highlight the increasing privatization of the governance of these programs, where states seek to delegate away or to outsource their human rights obligations to employers and intermediaries. Just to state that from a human rights perspective, healthcare or housing is not merely a job benefit, it is a fundamental right, and states continue to retain their duty to ensure the access to these rights without discrimination to every person in their jurisdiction, even if they're there on temporary visas. We found also that the focus of temporary labor migration programs on limiting the integration of migrants means that these migrants do not have access to longer-term, more secure legal status in the countries of destination, even if they've spent most of their working lives in these countries, even when they've developed enduring ties to that country or have weakened their bonds to their country of origin. We found that the temporariness of these pathways represents a formidable barrier to human rights protection. So what we're seeing really in this discussion today, and our guiding questions are, how can states, businesses, civil society, and other stakeholders collaborate to ensure that human rights standards are upheld in the design, implementation, and monitoring of these programs? What does justice and remedy look like? Is one aspect of remedy a fundamental reimagining of these programs in the region so that we can achieve the same economic development objectives while addressing and remedying the human rights inequalities that are structurally built into many of these programs? And these and other questions will be addressed by our expert panel today, who are introduce as we speak, but I'm delighted to be joined, first of all, by Tomoyo Obokata, who is the Special Rapporteur on contemporary forms of slavery, including its causes and consequences. It's a pleasure to have you with us today. As the Special Rapporteur on contemporary forms of slavery, what are some challenges, experiences, and good practices on labor migration that you have observed globally, as well as trends that you see in the Asia-Pacific region through your work and your mandate? What are some of the relevant international human rights standards, for instance, that should be brought?
Great. Well, thank you very much, Pia, and thank you for attending this important session. I'd like to start with the international standards. Now, rights of migrant workers are recognized in a range of international human rights and labor instruments. First and foremost, Article 6 of the International Covenant on Economic and Social and Cultural Rights guarantees the right to decent work without any discrimination. That should include migrant workers, whether they are temporary or on a permanent basis. When we say decent work, we mean fairer wages, dignity, equality, and safe working conditions. They should be guaranteed without any discrimination. Another important instrument is the International Convention on the Rights of All Migrant Workers and Members of Their Families, which provides for the human rights of both documented and undocumented migrant workers. Unfortunately, this instrument has only been ratified by a handful of Asian countries, including Bangladesh, Indonesia, Philippines, Sri Lanka, and Timor-Leste. And I urge all other member states in the region to ratify this instrument. In terms of ILO conventions, there are instruments such as Migration for Employment Convention number 97, Private Employment Agencies Convention number 181, and Domestic Workers Convention, and so on. And finally, access to justice and remedies is guaranteed for migrant workers under the International Covenant on Civil and Political Rights, where we talk about something like restitution, compensation, rehabilitation, and non-repetition of violation, and so on. So it's crystal clear that they should be treated with, all migrant workers should be treated with dignity and respect in the same way as their own workers. In terms of challenges with regard to temporary foreign workers, or the temporary program, and first and foremost, in my view, is the closed nature of many of these programs where workers are tied to a single employer in Asia and Pacific. And that, unfortunately, creates power imbalance, and that makes it difficult for migrants to escape and report the instances of abuse and exploitation, because if they do, they'll be fired. That means they lose their visa status. They have to go back to their own home country. So they have no other choice, many cases, to keep quiet. And because of this, again, there are many instances of abuse and exploitation, but various states, in terms of good practice, are gradually changing. For example, even a country like Qatar and UAE have recently reformed so-called kafala system, allowing migrant workers to change their employers without seeking permission from their employers first. And Japan, in my country, has also recently is implementing the reform of the technical trainee program. We're making it easier for workers to change their employers. But by no means these are perfect. I mean, there's still a long way to go in all of these countries, but I think I'd like to certainly advocate for open work permit where workers can change their employers at their own will. And more regulation over recruitment agencies is also quite important in my view. And many Asian countries do actually have a good system in place with regard to their own nationals traveling abroad, whether going to Japan, Europe, United States, and the Middle East through MOU and things like that. And I think that's good. And many countries, as far as I can see, Cambodia, Indonesia, Laos, Malaysia, Philippines, Thailand, and Vietnam, and so on, have regulations in place. But I think more control over recruitment processes is desirable, not leading to all these private agencies, and that can lead to exploitation. And so in a country like South Korea has more control over their own recruitment practices, so as UK and other countries in the world. And do we have a couple of minutes? Well, right, and sorry, I'm just conscious of time, but in addition, in relation to access and to justice and remedies, the key theme of this week's forum, the challenge, first of all, is access to information is a key. The many migrants do not know about their rights and entitlement guaranteed under national labor and social protection laws. And because of the language barriers, first and foremost, and also the legal language is very difficult to understand, even for the domestic people. And how do you explain that to foreign workers is a challenge, I think, for all governments, whether they are in Asia and elsewhere. And it is therefore important to provide the information in the languages that the workers understand in terms of their own native languages, as well as how do you translate this complex legal language into something easier to understand. Many governments nowadays do provide information on the internet, but it is important to remember that not everyone has access to the internet and smartphone and so on, and particularly for those who work in the remote or rural areas, or those who are under strict control by their employers, or even criminals who have been, for those who have been trafficked and so on. And ideally, relevant information should be given through pre- and post-departure briefing in cooperation with destination countries and so on outside of Asia. And I'm glad to see that things like this is already happening in a country like Philippines, Sri Lanka, Laos, and so on. And I would like to encourage other countries to do the same. And in terms of actual access to justice and remedies, and there are so many challenges. Reporting mechanisms do exist, and also that there are also legal routes that they can pursue, such as criminal and civil proceedings, but they are lengthy, and it costs a large amount of time and money to pursue, and most of the temporary workers cannot do that because they have to go back to their own country. So what needs to be done in that regard, in my view, free legal aid, so that they do not have to pay for it. And some countries, Myanmar actually has a law allowing migrant workers to pursue, to allow migrant in that country to receive legal aid. So it's Philippines, I think. And other countries like Vietnam and so on have specific funding for their own nationals who have been abused abroad. The use of video links and so on is quite important for those who have returned to their own countries, so that they can still provide testimonies for criminal and civil proceedings, so that at least still possible for them to claim these compensations even if they go back home. But more to the point, the residency is quite important. So something like at least a temporary residence permits, including for undocumented workers, is quite important. They should be able to stay in a destination country and pursue various claims until that is completed. And that should also include something like the right to work. If they do not have a right to work, they cannot sustain themselves unless they are given funding, which is not necessarily the case. So something like that, I can also see in various countries. In Malaysia, they have a special permission to stay, and in Australia, I think recently implemented these measures to allow migrant workers to pursue claims against employers, and they can stay in a country. And these are, I think, examples of good practice, and so on. And there are some non-judicial mechanisms as well, like online platforms and mobile phone applications that migrant workers can use to report instances. But oftentimes, these are controlled by the state authorities. And once again, migrant workers are somewhat hesitant to approach the authorities due to the fear of reprisals by employers and law enforcement action. So that, again, requires us to think creatively about how to reach out to these victims so that they can report with confidence and anonymously without having any of these repercussions. So these are some of the things I just wanted to highlight, and I'll be very happy to expand many of these issues at the question. But I'll stop here for now. Thank you.
Thank you very much, Special Rapporteur, and thank you particularly for highlighting some of the systemic issues, but also the power imbalances. And I think that, when we see who is taking on to these pathways, the fact that you don't have a secure legal status, you are in this permanent temporariness, as some people have pointed out, means that remedy can be very challenging. So thank you very much. And as you said, I'm sure we'll come back to expand on some of your recommendations. I'll move on then, Australia was mentioned, I'll move on then to our second speaker, James Cockayne, the Anti-Slavery Commissioner for New South Wales. And I should say that the full biographies of all of our panelists are available on the website, so please do click through and see all the amazing work that the panelists bring to this discussion. James, I wanted to ask you what kinds of human rights risks exist in labour migration schemes in Australia and the Pacific more broadly, and how do you address them as the New South Wales Anti-Slavery Commissioner? Is there any progress that you can share in this regard, as well as, of course, the challenges?
Thank you so much, Pia. Great pleasure to be with you all this morning. So I'm James Cockayne. I'm the Anti-Slavery Commissioner for New South Wales, which is the largest state economically in Australia. It's the 8th largest economy in Asia. I want to be clear that I don't speak for the New South Wales government or indeed the Australian government. I'm an independent statutory officer, so I report to the New South Wales Parliament. And indeed, just last week, we issued our first own motion report to the New South Wales Parliament, looking exactly at some of these risks, specifically at the modern slavery risks that confront temporary migrant workers working in 3 sectors: horticulture, agriculture and meat processing, specifically in rural and regional New South Wales. So I want to share with you today a little bit about what we found. Australia, as you probably know, is the home to the longest continuing culture on earth in our First Nations peoples. But for the last 250 years or so, we've been settled through waves of largely permanent migration, largely settlement. Over the last 20 or 30 years, however, there's been a bit of a shift in the visa settings in Australia. And so we have many more temporary migrants now, including over 700,000 international students. Perhaps some of you have studied in Australia. Those students often have work rights and often face some of the challenges of isolation and precarity that we've talked about, but also often have very happy experiences. We have around 20,000 working holiday makers just in my state alone currently. Historically, people thought of working holiday makers in Australia as European backpackers. Today, the largest cohorts are actually from Asian countries. And we also have the Pacific Australia Labour Mobility Scheme, a special scheme set up to allow workers from Pacific Islands to come to Australia, fill shortages in particular labour markets, send remittances home, contribute to development, contribute to positive outcomes for their communities, their households, all the things we know that remittances do. And on the whole, again, most of these people have a very positive experience. But what I learned when I started travelling around rural and regional New South Wales when I was appointed about 2 years ago is that we see a small group working in those schemes who do face very chronic problems that exactly along the lines that have been described. So we found that there were risks that some workers were falling into forced labour, debt bondage, deceptive recruiting, and in certain cases potentially even servitude or sexual servitude. We found issues that are pretty much stock standard for all of the issues that temporary migrant workers face across the region. So issues around working conditions, wages and entitlements, with wages often being either underpaid or withheld, or excessive charges being docked from workers for accommodation, for access to refrigerators or to washing machines. We found it very difficult for some workers to access their retirement savings. We have a mandatory retirement savings scheme called superannuation in Australia. It can be very difficult for migrant workers to access that, especially once they've gone home. We found some issues around health and safety, but in particular what we found is that the issues are often not in the workplace. We have a strong industrial relations system in Australia. It's often in the life of the worker that is not thought of by the industrial logic of treating them as a worker. Back to your original point, Pia. It's all of the stuff that goes on around family life, around your living space, around how you get to and from work. Where you socialise in your relationship to alcohol and all of those kinds of things. So accommodation, transport and living conditions were a big issue. This was absolutely, the risks that migrant workers face were absolutely dependent on their intersectionality. So there are very different risks for men and women. We saw particular risks around gendered violence and healthcare access, with some temporary migrant women and children experiencing violence, often again not in the workplace, but in their life outside the workplace. And in some cases that did appear to rise to the level of modern slavery, sadly. This is particularly a chronic risk for those people who choose to disengage from the formal program, which is a small minority of workers, but certainly appears to be in the thousands under, for example, the Pacific Australia Labour Mobility Scheme. When you disengage from that program, you become precarious in your visa status, and you lose entitlement, for example, to healthcare. So for example, for women who fall pregnant unexpectedly, that can become a real risk. So it was shared with me on my travels through southwest New South Wales and indeed on the Central Coast that women were presenting to hospitals to give birth having received zero antenatal care and with a lack of clarity about how they became pregnant in the first place. Then, of course, all of the questions of stigma that attach to that kind of unplanned pregnancy can become very chronic and also leave women in positions of vulnerability. And finally, we see issues around isolation and social marginalisation. So what we call for in the report, which we called Be Our Guests, and you can find it on our website if you'd like to Google Be Our Guests, NSW Anti-Slavery, you should find it on our website. What we called for in our report is really a more co-regulatory approach. So governments at all levels, we have 3 levels of government in Australia, local, state and federal, working together with local communities to try and ensure that our guests in the country are able to access and realise all their rights and are able to live as rounded human beings and not just as commodified labour inputs. The federal government, I want to acknowledge, has already made a number of moves that are very positive in this direction, and I'd like to particularly acknowledge Cressida McGarrigan from the Department of Home Affairs, who's with us today, who's played a key role in a number of important initiatives already referred to by Tamoya that improve mobility for migrant workers, and that this really groundbreaking workplace justice visa that allows workers to stay in the country in order to pursue a justice claim when they feel their rights have been violated. It's quite groundbreaking. It's going to be a bit of an experiment, and it will be interesting to see how it plays out. There are some technical questions around exactly how different visa classes interact, for example, with Pacific workers, but we see that as exactly the right kind of direction of travel and want to encourage the federal government and indeed the state government to do more in this direction. We also think local communities play a really key role here. So the kinds of issues we're talking about in our report are not the majority experience of migrant workers. They're the problems at the margin, but those problems we fear risk becoming so grave that they actually could put the social licence of these migrant work schemes at risk. And I mean that in 2 senses. The social licence, both in sending countries, as news comes back of some terrible experiences people are having, but also the local social licence where migrant workers live. We find that when things go wrong, it's often local communities in New South Wales that are stepping in and bearing the brunt of providing services, often under-resourced. So in one part of New South Wales, for example, we were told by local community service providers that they'd not only run out of crisis accommodation, beds, to give people who disengaged from the PALM program, they'd actually run out of tents. They'd run out of beds, so then they started handing out tents so people could sleep in parks. They ran out of tents. So it's some quite simple resourcing questions and a need for this more joined up approach to governing these schemes to ensure that they are working as best possible for all of the positive benefits that they render for everyone. And we think that the basis for that is to take a more rights-based perspective. So I hope that's illustrative of the kinds of both problems that are emerging but also solutions that are emerging, and looking forward to further discussion.
Thank you very much, James. And the report that you mentioned, as you said, very, very important resource. I mean, I hope that everybody does try to access it, because the recommendations as well that you mentioned speak really, I love this idea about rounded human beings, but also that people exist in communities. And that's something that we don't come across often enough in the context of temporary labour migration programs, with the idea that people are just there very, very fleetingly and won't be there much longer. But of course, everybody exists for however long within these communities, and bringing those into the conversation around remedy, around rights fulfillment, I think is really, really important. So looking forward as well, congratulations to the Australian government around some of these justice mechanisms, and we look forward to hearing more about implementation and how that kind of rolls out, but also as promising practices within the region. So thank you very much, and again, I'm sure that we'll come to the conversation, in more details about some of the issues that you raised. We're now going to speak from another national context to Stephanie Chok, who is the Executive Director of the humanitarian organization for migration economics, HOME, is an NGO based in Singapore. And Stephanie, I'd like to ask you how temporariness is embedded for low-wage migrant workers in Singapore, and what are the human rights concerns that you're seeing? What lessons are there for other countries, as well as, of course, for your own country who wish to implement temporary labor migration schemes in this way? Thank you.
Yeah. Okay. Yeah, thank you so much, Pia. Thank you so much for attending this session. I'm very grateful to be here. So in Singapore, our NGO sees similar issues regarding temporary migrant workers that have been raised by others: exorbitant recruitment fees, persistent wage theft, hazardous working conditions, inadequate access to healthcare, and deception and coercion leading to forced labor-like conditions. This is attributed to a combination of errant employers, unethical recruiters, and the vulnerabilities that are engendered by the ways temporary labor migration schemes are structured, and that will be my emphasis using Singapore as a case study. So in Singapore, we have a very large, relative to our national population, large migrant workforce, and it's quite diverse. We have higher earning foreigners on employment passes. These are, your investment bankers, your tech workers. We have mid-tier PMETs on S passes, and then we have a much larger population of work permit holders. These are low-wage temporary migrant workers on employer-tied, renewable work permits, and they work in sectors like domestic work, construction, shipping, F&B, and hospitality. There are just over 1 million of such low-paid temporary migrant workers in Singapore, where our total population is just 5.9. In the region, Singapore is a bit of an outlier. We have a large migrant workforce, but irregular or undocumented migration is not an issue, it's an exception. So what we have is a highly regularized migrant workforce under a temporary labor migration scheme that is highly stratified, extremely discriminatory, and in fact it contravenes numerous human rights standards. Yet it remains legal, largely accepted, and vigorously defended by policymakers. So I'm going to bring you through some of the key features of this temporary labor migration scheme. Okay, so like I mentioned, we have different passes. I'm going to focus on the work permit for temporary migrant workers with a specific emphasis on domestic workers. So there are restrictions on change of employer. Whether or not you can change your employer depends entirely on whether or not your current employer gives you consent. There's no pathway to permanent residency. You could work as a domestic worker in Singapore from the time you're 23 to the time you're 55, and you cannot apply for PR. There's a denial of family reunification. You're not allowed to bring your family over to live with you. There are restrictions on marriage. If you're a work permit holder, you are not allowed to marry a Singaporean or a PR without permission from the controller of work passes. There are restrictions on your reproductive rights if you are a female work permit holder. If you are found to be pregnant, you will be deported and blacklisted and not allowed to return to work to Singapore for a period of time. How does the state know if you're pregnant? Because if you're a female work permit holder, you are subjected to mandatory 6-month medical checks in which you'll be tested for pregnancy and STIs like syphilis every 2 years for HIV and tuberculosis. On top of the restrictions on your rights, there are several control mechanisms imposed on employers. Employers of every work permit holder has to pay a foreign worker levy to the state. In some perverse situations, the foreign worker levy to the state every month is higher than the migrant worker's salary. As an employer of a work permit holder, you have to furnish a bond of $5,000 to the government. This bond could be confiscated by the state if your foreign employee breaches any regulations. There are source country restrictions if you're a work permit holder. This means that the government will determine which sectors you can work in depending on which nationality you are from. Domestic workers, in addition, are excluded from the Employment Act. This means they are bereft of basic labour protections governing their working hours, things like sick leave, paid annual leave, etc. There's also a clause in the work permit regulations for work permit holders that says the foreign employee shall not be involved in any illegal, immoral, or undesirable activities, including breaking up families in Singapore. This seems specifically coded for domestic workers. And because there is the security bond that employers have to pay the state, this leads to a lot of moral policing by employers who are also very concerned if the domestic worker falls pregnant and has to be deported. In addition, there are no minimum wage laws in Singapore, so it is not illegal for a business or an employer to pay someone as low as $1 per hour. So wage stagnation is a huge problem. In the 1990s, Bangladeshi construction workers were getting a starting salary of $16 a day. We are now in 2024. We still see Bangladeshi workers getting starting salaries of $16 a day, and I mean Singapore dollars, not USD. So, economic pragmatism, unfettered, can result in a regime like this. And the key takeaway here is that regularizing migration does not necessarily or automatically lead to better labor and human rights protections. There needs to be an explicit emphasis on a rights-based approach. States and businesses should not be allowed to perform compliance, to cocoon themselves under the veil of legality when labor standards are weak or inconsistently enforced, especially when they're operating in business-friendly authoritarian regimes, where you have this very problematic combination of poor labor standards and restricted political liberties. In Singapore, social reproduction is considered an externality. Others have referred to the fact that temporary migration schemes are actually not that temporary, right? There's a permanent temporariness because work permits just get renewed over and over again. If we adopt a rights-based lens, I would say that what we have is a system of permanent disposability. You're welcome if you're healthy, productive, compliant. You're very readily and easily discarded if you're injured, pregnant, contract an infectious disease, or refuse to comply. As William from Migrant Forum Asia already said in the earlier session, many temporary migration schemes are fundamentally flawed from a human rights perspective. And as more countries promote and attempt to adopt this model, it is important to critically assess the principles and values that underpin such regimes. We need to continue to expose and object to the ways discriminatory, anti-rights practices are embedded within them. Otherwise, over time, and this is why it is so insidious, they entrench and normalize extractive, discriminatory, and exploitative systems and establish them as the status quo. That's all from me for now.
Thank you very much. Thank you very much, Stephanie, and thank you. I think that was a very powerful witness that you brought to the extractive nature of what you're seeing from the perspective of the CSOs. It struck me as was very striking when on your chart the discrimination that's embedded when you're looking at the other categories of migrant workers essentially that are there, which really brings us, I think, to focus in on where the gaps are and the vulnerability is regarding this low wage temporary, labor migration and the element of permanent disposability that you mentioned. So thank you very much, and I think that there's a lot to dig in. I'm sure that there will be questions and comments to you as well as we move on. Thank you. So our last but not least speaker on our panel today, Rasika Jayasuriya, is a migration policy and human rights consultant who's worked extensively around issues related to temporary labor migration. And the particular question I have for you, Rasika, is how does the family separation that we've heard is embedded in temporary labor migration affect the rights of the migrants and the migrant workers themselves, but also the rights of children and families within this context, please?
Thanks, Pia. So if we're thinking about migrant workers as human beings, then as you said earlier, Pia, we know that they are also parents. They have families and they are caregivers. It's completely foreseeable, as workers are typically of childbearing and child-rearing age when they migrate. This has led to millions of children of migrant workers in the Asia Pacific growing up in the physical absence of one or both parents, their mothers and their fathers. And this is despite these children, like all children, having the right to grow up with their families, which includes both parents, regardless of migration status. Likewise, the critical and protective role of parents as primary caregivers in their children's upbringing and development applies equally to all children. It doesn't differ if you're rich or poor, brown or white, migrant or national. But we know that labour migration schemes rarely include a viable option for family accompaniment to encourage the permanent temporariness that others have already talked about. While labour migration discourse and agreements now at least acknowledge inherent risks to the rights of migrant workers as workers, their rights as parents have been largely ignored, and as have the interdependent rights of their children. Article 3 of the Children's Convention obliges states to consider children's best interests in all policies and actions that affect them. It is obvious that policies requiring workers to migrate without dependent children will affect children. Yet, there has been a complete omission of any systematic and comprehensive consideration of children's best interests in the design and development of temporary labour migration programs. The Children's Convention's near universal ratification means it legally binds both labour-sending and labour-receiving countries. As you can see, there are numerous rights under the Children's Convention that protect the child-parent relationship in the context of temporary labour migration. And these include the rights of children to be cared for by their own parents as far as possible, to maintain direct and regular contact with their parents if separated, and to have their parents assisted by the state in their role as caregivers with the primary responsibility for their children's upbringing and development. The Convention defines children's development to include their physical, mental, spiritual, moral and social development, recognising and protecting the parental role in providing for children's psychosocial and emotional development needs on par with their physical and economic needs. But instead of assisting parents to fulfil this responsibility, temporary labour migration forces them into a transnational relationship with their children on a false assumption that remittances compensate for gaps created when parents migrate. This slide shows how once this happens, there are measures that can help parents to maintain their relationship and parenting role transnationally over short periods of time. However, structural features of temporary labour migration, such as restrictive visa conditions, low wages, inadequate leave provisions, and the encouragement of remigration, prolong periods of family separation. And these prolonged periods significantly disrupt children's family life, creating potential harms to children that states and businesses are failing to mitigate. This is despite a universal recognition that strong child-parent relationships are central to children's development and well-being, which is why states agreed to protect the role of parents in the Children's Convention in the first place. We have no shortage of evidence about the potential harms to children, families and communities arising from the prolonged absence of migrant workers from countries that have been pursuing this as a deliberate economic strategy for decades. Current research shows the same child protection concerns emerging with newer labour migration schemes like the Pacific Australia Labour Migration Scheme that James mentioned. The excerpt on the slide shows findings from public health experts who conducted one of the largest reviews of research on the effect of parental migration on the health of children and adolescents in low and middle income countries. And a study from the Asia Research Institute gives voice to the next generation, interviewing children of Indonesian migrant workers who have transitioned into adulthood and are expressing that they have had enough of migration and are placing a higher value on proximate family life when starting their own families, with some viewing migration for development as, and I quote, an incoherent strategy that works against rather than for the family. Obviously, positive and negative outcomes for children of migrant workers differ based on specific circumstances. When families are able to successfully support transnational parenting arrangements, it is generally with little assistance from states, and it is dependent on factors such as employer discretion, access to resources, and the suitability of alternative caregivers. Migrant workers often do not foresee how long they will be separated from their children, with separation prolonged by factors beyond their control, like restrictions on their movement, limited resources for frequent reunification, development of familial dependence on remittances, demanding remigration, and indebtedness to recruiters. Such structural features unnecessarily prolong child-parent separation in ways that we just do not do in other contexts. So what's the difference? In other contexts, the children and parents are either nationals or skilled migrants. For example, with military families, we see significant investment in family preparedness and support before, during, and after deployment, and often additional support in schools and public services. In family law, we see guaranteed rights for frequent communication and visitation between children and non-resident parents, and for parents and children to be together for events of significance. With fly-in, fly-out workers, common in industries like mining, we see week-on, week-off employment, with travel fully funded by employers. And with skilled migration, not only is there family accompaniment, we have freedom of movement, resources to travel, unrestricted communication, family leave entitlements, and often portable social protection. So I want to stress that short of family accompaniment, there are practical and preventative measures that states and businesses can put in place to mitigate potential harms to children arising from their parents' migration. And when temporary labour migration becomes de facto long-term, then there should be options to adjust entitlements to allow for family accompaniment. Such measures would bring temporary labour migration programs closer in line with human rights standards and reflect the reality that unless these programs are rights-based in their construction and execution, they will not deliver sustainable development outcomes for children, communities, and countries of origin. To finish, states and businesses simply cannot keep turning a blind eye to this issue. We know the risks of separating parents and children, and we know from other fields and other forms of migration how to effectively manage these risks. Thanks, Pia.
Thank you, Rasika. That's very, very important. And honestly, one of the first few times that I've heard about, bringing children so centrally into this picture. And raising the red flag around, how do we, given the stated aims of these programs to achieve economic development goals and the SDG agenda, when looked at holistically, the risks that we see of the agendas not being fulfilled because of the child rights concern. So thank you again very much, and thank you to all the panelists for excellent interventions. We're running a little bit late, but I did want to, first of all, allow time for these wonderful interventions, but I would like to open the floor now for a few comments. I'd ask you please to all keep your questions and comments really, really short, if you could. Start with Adrian, please. You had your hand up first.
Hi, good morning, good afternoon. Sorry, I came in a bit late. With regards to migrant workers' health care, there's enough advancements in medical science, for example, to ensure that these so-called communicable diseases are managed. TB is manageable, HIV, PLHIV, we have undetected equal to untransmittable. And we see migrant workers with these conditions, and I think we shouldn't criminalize them. One of my friends, Fajar from Tenaga Nita, he reminds us that we want migrant workers to come to our country, but leave their genitals behind. And I think it's very cruel that we treat them in a way that separates them from reproductive health. So these are my 2 points. Thanks.
Thanks. I'll take a few. Yes, please. The gentleman at the back.
Thank you so much. A very good morning. I'm Gautam Bhardwaj from India, a practicing lawyer. So basically, we are talking about the migrant workers. So I just want to add a few things in that along, followed by a very small question I will be coming up with. So it is actually with regard to the laborers who are actually falling under the organized sector and unorganized sector, right? So what we can actually do about it, like we can just identify them who are working in different areas and in the different sectors of the work, which are being operated by the state governments or maybe on a private note, one thing. Secondly, it is actually with regard to the bonded laborers and the forced child labor and forced labor. And accordingly, I believe that in all the states, I think we should actually have state social security board and the construction worker welfare board to resolve their grievances or to sort any kind of a problem what a laborer is actually facing over there. So, and there's one question like which I really want to put now is actually with regard to the third party. Because third parties are basically, they are engaging all these laborers and they are just sending all these laborers to different parts of the world to their respective employees. So what relation can be built up between a third party and the employer to secure their rights? So this is my question. Thank you so much.
Thank you. There's a gentleman behind you that had his hand up as well, please.
Thank you, Madam Chair. My questions to Special Rapporteur on contemporary forms of slavery. My name is Ajay Kumar. I am representing an alliance of climate frontline communities. Sir, the colonial industries established centuries back, especially the plantation industries, be it coffee or tea, thrived by exploiting the vulnerable communities, the marginalized communities, almost like enslave them in these plantations. And over the period of time, it is not changed. It is transformed into a potential modern slavery or contemporary slavery situation. That's one aspect. Second aspect, these set communities, be it Dalits, Adivasis, pastorate communities, Maasais across the globe, these geographies and these communities are now affecting by the climate change induced events, disasters, and thus force them to migrate. So are you, I don't know how appropriate to ask you in this public, are you consider, this aspect is one of the, highlighter in your next report, or think of having a report on focus on this issue? Thank you very much.
Thank you. Maybe somebody from this side? Yes, in the front here, please.
Thank you for calling on me. My name is Viraj Kamath, and I represent Rare Gen Youth Network, an NGO focused on human rights advocacy for people with rare diseases. Migrant workers with rare chronic illnesses face significant challenges under TLMPs, such as limited access to healthcare and legal remedies due to their temporary status. These issues are often overlooked, especially once workers return to their home countries. Therefore, my question is, how can TLMPs be reformed to ensure that vulnerable groups, like workers with rare diseases, can access the healthcare and long-term support they need, both during and after their employment? And what are the steps that can be taken to align these programs with international human rights standards to guarantee better protection for all migrant workers? Thank you.
Thank you. Maybe we can take just a couple more. Yes, Pepe.
First of all, thank you so much for a great panel, and to all the panelists. This has been really thought-provoking. And it's Pepe from IOM, and we also find that the discourse on labor mobility is increasingly on the unit of labor cost, right? We talk about labor rights also, not human rights often. It's just the way that the discourse seems to be going. But migrant workers aren't only cheap in terms of the labor costs, but they're also cheap because they come fully formed to the host governments, right? So they've been educated somewhere else, and someone else will look after their old care needs. And sort of one of the low-hanging fruits, or what should be a low-hanging fruit if there are any, would be the portability of social welfare benefits. But we really don't see this happening much at all in this region, right? The technology is there, we know how to do it, but it's not part of the labor mobility agreements, which anyhow tend to be more MOUs than binding ones. So do you see any good practice here? Where could we start? Thanks.
Thank you very much. Yes, the gentleman at the back.
Good morning, everyone. I am Akash Yadav. I am a legal practitioner from India. First of all, thank you so much to the respected panelists for such an insightful session. My question is with regard to the collaboration between sending countries and the host countries. That how can the collaboration between sending and host countries can be improved for creating a mutual beneficial migration agreements. Thank you so much.
Thank you. Are there any, maybe a couple more? The gentleman here. Sorry, if I may, I'll give it to the lady in the front. The lady in the front here. Thank you.
Thank you very much. I'm from a trade union in South Korea, the Metal Union. We used to have an industrial trainee program in 1991. It was incredibly exploitative and rights restrictive, and migrant workers themselves, supported by trade unions and church groups, fought against it, and it was abolished in 2007. and an employment permit system was made instead. It's still restrictive. We're still fighting situations on the ground where migrant women workers are sexually violated, but then are afraid because they can't freely move their workplace. But in the course of this, our government formed a rebirth of the industrial trainee system for the shipyards. So now they're restricted not only from moving their job, but from the region. And they're also, it's not publicly, but there are recruitment brokers and then double contracts and so on. So I was hoping that you could point to some good practice. I mean, we obviously are going to try to help protect the migrant workers' rights and organize them. But then, you know, it took an extremely long time in a big fight of migrant workers themselves to abolish the industrial trainee system. So now that it's reborn in this shipyard scheme, we are hoping there's some other resources now that we don't have to go back to that. But, you know, if you have some good practices or point to something that we can refer to, I'd be grateful. Thank you.
Thank you. We'll take another couple of questions. There was a gentleman behind, yes, and then yourself.
Yeah. Okay, thank you so much, and they're very great, insightful, and excellent discussion. Yeah, during their discussion and challenges and the regarding and the migrant workers' access to effective remedies within, the temporary stays, as well as some good practices implemented by certain countries were highlighted. But in particular, and it was emphasized that creating a system where migrant workers are not tied to a single employer and can change your employers freely is crucial. To further and promote this and standardize it internationally, what kind of international cooperation and the legal frameworks do you think are necessary? And additionally, could you share your thought on the specific and the challenges that government and the businesses face in implementing and such reforms and their practical approaches to overcome them? Thank you.
Thank you very much. And the last question from the gentleman here, please.
So thank you very much indeed for giving me the floor. I was really moved by the presentation given by the Singapore person. And this was quite difficult to digest that a country like Singapore, where, we have been hearing this with what you call where the democracy, whatever, is functional somehow. The number of migrant workers are double than the actual population, and the happiness index is like 30th in the world. How come the treatment like that is going on with the workers? And what about the civil society within the Singapore territory? If they are actually doing anything for the workers' rights over there? And if not, what is the reason? Do you have any civic space, open civic space to talk on such issues? Thank you.
Thank you very much. Thank you for the excellent questions. I'm going to turn back to the panel and maybe just give you the floor in turn so that you can address the issues that and the questions that came up relevant to you. Please, perhaps, if you could, when you answer as well, think about some of those more systemic governance-related issues that have been brought up and give us your recommendations for how we might address. Special Rapporteur Tomoya, can I give you the floor to start?
Thank you very much. There's so many good questions, and I don't know if I can answer every one of those, but some other colleagues will be able to answer. Well, the third part, the point about third parties, I'm guessing is that about the recruitment agencies and so on. And I think, well, as I said, stronger control over the state governance is needed. Don't leave everything to the private recruiters. And I think that's, again, many Asian countries already do have regulations, but they still may charge fees to workers. I mean, that happens. So who actually monitors it? So stronger monitoring mechanisms, or actually state taking over the entire recruitment. I think that may be a very good step forward in cooperation with civil society and others. And that seems to be happening in some countries on the point of displacement, and I think that's a very good point. a few years ago, I did my report on displacement and contemporary forms of slavery. It's also something like people forced to move because of natural disasters and armed conflict, how that affects. And I would encourage you to read that particular report. Collaboration between sending and host countries. I mean, this comes up all the time, particularly in Asian context where many Asian workers actually go abroad. And there are MOUs, as have been highlighted, is I think legally binding mechanisms needed and to introduce, for example, written contract for all workers so that they can legally enforce these programs and so on. And I think it's very difficult, but the multi-stakeholder approach is crucial, involving workers. Their voices needs to be heard, exactly trying to understand what they actually want, workers' organizations, CSOs, and all of those have to be on the table to decide on these things. And it's not just a government thing, so I do encourage other governments to do the same. And finally, the remedies, a closed system, as I said, is problematic. And I went to Canada last year, and they do have a temporary foreign worker program, and I, have lots of issues in that regard. And I think businesses and so on also want to keep it because they invest so much time and effort in recruiting these workers. And I think that kind of creates that, again, power imbalances. So we need to change the system. So again, in terms of recruitment, not necessarily the employers who should be doing that, some other kind of state or independent bodies taking control. And I don't see why you can't open it up to all sectors. Why does it have to be tied? So if, for example, Japan is moving towards that direction, then I'm sure that other countries can do the same. It's also about labor shortage. As long as you make the accurate assessment and then government taking charge of recruitment, and I think that may kind of gradually reduce. But I mean, that's not a solution, but in conjunction with other considerations. But it is a complex issue, I think, and there's no single answer. But sorry, I'll stop there for now. Thank you.
Thank you very much. James, may I turn over to you, please?
Thank you. I think I want to offer just a couple of thoughts in response to a number of the questions, and in particular the questions about portability and the discourse and where it's going. In my view, the challenge here is for us to move away from an extractive logic in migration, seeing migrants as, what was your memorable phrase, Stephanie, permanently disposable, and recognizing that actually migration is a shared asset. It's a shared enterprise, and it's being undertaken all over the region. I think the region actually here could learn in some ways from, and I include very much Australia in that context, from experiences of migration and shared governance of migration in Europe. So the European political project began with an emphasis on movement of goods, and gradually there was a recognition that there also needed to be movement of people to achieve the economic benefits. But over time, the political externalities of that movement of people and the importance of how that needs to be managed have become clear. In Asia, we've seen massive growth in the last several decades as a result of movement of goods, and now we're at the stage where we're grappling with all of the complex political and rights-based questions around movement of people. Let's not make the same mistakes that have happened in some other regions whereby treating individuals just as labour inputs, we've not planned for the externalities that brings, including the way it passes down intergenerationally in the way that Rusika has described. And for me, that has specific governance implications. It means that we shouldn't be looking at migration just in terms of bilateral migration corridors and just in terms of agreements between individual sender and sending states. Migrants are competing in a transnational market. They're very aware of the different outcomes that they'll get from going to different countries and the different issues, particularly in a information environment like we have now, where that information spreads like wildfire through WhatsApp, for example, through diaspora networks. So I think there is actually a space and opportunity for a much more multilateral approach, including around some of the schemes we have in Australia. There is a Pacific migration scheme to New Zealand that is not co-governed with the one for Australia. So in a sense, we're competing into the same labour markets for migrants. That sets up all sorts of perverse incentives. We'd be better off, in my view, and it's purely my view, I don't speak for any government, taking a more multilateral approach to these governance. And if we do that, then the common starting point is obviously going to be around existing labour standards and human rights.
Thank you very much for that, James. Maybe, Stephanie, if I could come to you, please.
Okay, so maybe I'll just first address the young gentleman who talked about the rare diseases. So in Singapore, you don't even have to have a rare disease. A very middle of the road one will get you deported. But I would say that then centering the right to healthcare would be very important, because in Singapore, migrant workers don't even get healthcare subsidies. So we need to recognize the right to healthcare for all migrant workers. In terms of the relationship between countries of origin and countries of destination, that was something that I did want to mention, which is regional politics. So there's a grave imbalance of power between migrant workers and employers, but also grave imbalances of power between countries of origin and countries of destination. The Philippines Embassy actually has a mandated minimum wage for Philippines overseas workers. Singapore government does not enforce it because they say that's Philippines law, doesn't apply in Singapore. So we are not going to enforce that. Right? So where are the levers of power there when countries come to negotiating table? Countries of origin want better rights for the migrant workers working in countries of destination, but countries of destination are often wealthier, more powerful in the region, right? CSOs and also lend a lot of support in the region to migrant workers who need that support to be able to have access to remedy. But the spaces for CSOs are also shrinking. And I would say then, to kind of segue to the point made by the South Korean lady, that we just need to fight. In fact, we really admire what's happening in South Korea, that there's migrant workers self-representation, which is completely unheard of in the Singapore context. So migrant workers need freedom of association. They need to be able to have the power to speak for themselves, to fight for their rights together in concert with the CSOs. And that brings me to your last point, sir. And yes, you are right, my government has very good PR. So I'm glad for the opportunity to come here and dispel a little bit of the myths. As for what happens to CSOs, to be honest, it is a bit of a risk, and I was quite nervous to speak so freely. But I see my position here as one. I'm invited as a CSO representative, and therefore I speak as one. Right? There's no point for me to sugarcoat and tell you everything that a business or government representative is going to tell you. That is what I owe as my position as a CSO rep. And I would say for all the businesses and governments here looking for partners, watch out for the gongos dressed in NGO clothing, because that is the new strategy of many states, especially in this region. They co-opt the space. There are shrinking spaces for CSOs everywhere, and every business wants to work with a CSO now, right, to increase your credibility. So make sure that you choose independent CSO partners. Yeah.
Very important. Thank you very much, Stephanie. And finally, Rasika, could I come to you, please?
Thanks, Pia. I'd just add a little bit on the social protection that Pepe mentioned. I don't have examples to share as you asked for, Pepe, but I just stress that in the context of children's rights, it's especially important to have that portability, because social protection is such a protective factor in reducing risks of harm to children and risks of negative coping strategies like child labour and child marriage. And also because children of migrant workers in countries of origin are often excluded from social protection within their own countries because their families receive remittances, so sometimes they're perceived as not living in poverty, even though we know that remittances don't always correlate with a reduction in poverty. So the portability of social protection and access to social protection in countries of origin both are exceptionally important to children. And just on the broader governance kind of question, I just stress that temporary labour migration at the moment is really premised on separating out workers from their families. And so I think there are obviously really big things that need to change, like making decent work in countries of origin a really viable alternative so that parents can provide financially for their children whilst also living with them. But short of that, there are smaller things that can be done at the structural level, like those things that I talked about and others. And yes, they will cost money. But it's not the sole responsibility of labour source countries just because that's where those children live. Incorporating and funding those measures is really a shared responsibility between all the parties involved in the design and implementation of the program, including business, particularly given that resource inequity and the imbalance of power that Stephanie talked about. I have no doubt that its financial implications of these measures are massive barrier to labour receiving countries and businesses taking action and doing something about this issue, the particular issue of children. I mean, it's much easier for them to say, you know, we didn't know about it, or it's not our problem, they don't live here. But, you know, these programs should never have been designed the way they are in the first place. So it seems costly to put these kinds of protective measures in place just because it's been so cheap for so long.
Thank you so much. Thank you also for those incredibly reflective, you know, thoughtful responses as well to some excellent questions. We're going to, with thanks as well for your patience, we'll wrap up. But I'd just like to leave you with just a couple of thoughts, drawing really from the excellent interventions, both from the panel and yourselves. And the main learning that I will take away is that, of course, these programs may be temporary. Some of them should be temporary because they fulfill really temporary or seasonal labor needs. Some of them should not be temporary because, in fact, they are fulfilling longer-term stable needs. But regardless of that, the human rights of the people that embark on these programs, of their families that are either left behind or with them, these rights are permanent. They attach to the person. They don't attach to the place where the person is or the particular visa status that the person and their families have. And so centering those standards in the initial implementation, the wish thinking about what a program might look like in its design, in its implementation, in its monitoring and evaluation are crucial. And I would say as well to those of you that are in the room engaged in advocacy, engaged through being businesses that might be looking or facilitating these pathways as governments, it is critical to talk to the migrant workers and their families, but it's also critical to ask them about their experiences that go beyond the workplace, because then you might understand, you know, the kinds of harms and the kinds of impacts that our panelists have talked about. If we don't ask migrant workers and their families, what family life means to them, if we don't speak to migrant workers about their access to healthcare, their access to housing, do they want to live in dormitories? Do they, want to have the ability to rent, to be paid a living wage to rent? We're not going to ever learn these things. We have to talk about the whole of the human rights standards that apply to the migrant and their families on these. So I would really encourage you to ask these critical and holistic questions as well. With thanks again to our wonderful panelists, Stephanie, Tomoya, James, and Rasika. Thank you very much. And thank you to the audience. We'll end there. Thank you.